Okay folks, so Alex Woods here, your friendly, cheerful litigator from Redwood Legal. I'm a specialist in cohabitation, property disputes, contested wills, general litigation, and we also run a litigants in-person help and advice service if you're running your own claim. Book shortly to be published this autumn, your paperback wing for the county court system of England and Wales. So today I'm going to try and make as simple as I possibly can the mechanics of a no-win, no-fee agreement. What is a no-win, no-fee agreement with a lawyer? I did one of these a while back, and one of the comments was, "Thank you very much for this video, clear as capital letters mud, M-U-D." So my ego was bruised. I also reflected on that and I thought, actually, let's really try and boil this down and make it as simple as it possibly can be. So if you are a member of the public or a business and you feel you have got genuine merit in a case, but you just simply don't have the money to cash flow the legal fees possibly all the way to an expensive trial, then stay tuned. The skinny on no win, no fee. Right, so imagine that you are someone who has perhaps been left, maybe in a will, a treasure map, and it's a pretty good map, but obviously you don't have a ship, you don't have any way to get to the particular location. It's a treasure island situation. So you go down to the docks and you speak to a skipper and you say to him, "Look, I've got this treasure map, it's on an island, there's this massive load of treasure on this island, I need you to help me to get there." And the skipper says, "That's fine, this is my day rate." Okay, and you go, okay, tricky thing is, it's like the treasure's over there and I'm not, made of money, so I was kind of wondering whether we could do some sort of a deal. And now you are immediately in a kind of an unorthodox, slightly different form of arrangement completely different form of arrangement with your lawyer, because you are asking him to become a partner. You're asking him to become a business partner. And the two of you are going on an entrepreneurial adventure, an entrepreneurial endeavor, a commercial venture in which you both have calculated the risks and you decide that it's worth the risk because of the potential upside of this pile of treasure. Now, so he says, "Oh, okay, well, if you don't want to pay me my day rate to keep the ship afloat and for me to pay my crew, then I'm going to have to take a share of the treasure." Okay, and the question, of course, will be, well, how much of that treasure am I going to take? Now, when you think about it, since it might be a long sea journey, since it might be a big or a small amount of treasure, you don't perhaps, as far as the captain's concerned, he doesn't know. You tell him it's a huge pile of treasure, but he's never seen it. So he's in risk of not being paid anything at all if the whole adventure is a failure. And let's be honest, just like shipping, a sea voyage is fraught with dangers and difficulties. He is going to double his hourly rate. Seems reasonable. Double the hourly rate, half the chance of getting the treasure, I get to double my hourly rate. And that is what is commonly called in legal parlance a success fee. It's that doubling bit. The half is the normal rate for running a ship, and the other half is the special rate because you can't pay him his day rate as you go. Okay, there you go. Now, there is an issue. You might have thought of it already. Problem is, you don't quite know how big that bill is going to be, do you? I mean, he's doubling his hourly rate, he's paying for a ship and the crew, and it could be an extremely long voyage. Maybe it's to a neighbouring island on the Channel Islands just off of France, if in our story you're based in Plymouth. Or maybe it's, in the Bermuda Triangle. So you just simply don't know how long is the journey is going to be, and you're worried that when you do get to this treasure, he's going to present you with his doubled up bill, and you're going to have a couple of coppers left. There's hardly going to be any treasure left for you. So you're on the docks with the skipper, who's probably done this once or twice, so maybe he's trying to pull the wool over your eyes, I don't know. Let's assume he's an honest skipper. And you say to him, look, here's the problem. He says, okay, no, I understand the problem, and this is what we're going to do. I am going to cap my doubled rate, so you never lose more than half of your treasure. So however long the journey is, however many perils and pitfalls we experience, when it comes to that treasure, I'm not going to take more than half. Or, in legal circles, 25% is a classic percentage that a lawyer will charge. Now, here's the interesting thing. He's not actually saying, I want half the treasure, or 25% of the treasure. Let's just keep it simple, half the treasure. I'm just saying that I will never charge you more than half your treasure. Okay, so that's why there is this cap. That's the word, a cap on the final bill that you're going to get from the lawyer. And if you are the chap on the docks planning to go on a Treasure Island adventure, obviously it's a pointless exercise if you think there's not going to be any treasure left when you finally arrive, because the skipper and the ship have taken it all. Okay, now here's the other interesting thing. That also presents a problem to the skipper, doesn't it? Why? Well, when you think about it, he doesn't know how much treasure there is, or how long the journey is. So you've told him, well, I've got this map and I'm sure that the treasure is, a million gold coins. And he's like, well, okay, who told you that? And you say, well, I've got the local barman told me about it. And anyway, but I've also done some research, and apparently, I've got the precise location of the treasure, and I can reassure you. Well, his eyes are going to roll into the back of his head, and he's going to say, right, okay. So he also needs to basically kind of protect himself. He needs to satisfy himself that there is a genuine amount of treasure that's going to be able to pay for his shipping bill. Don't forget, he's got a ship, he's got a crew, he's got repairs and maintenance. He doesn't want to spend a year absolutely nothing, having to pay his crew for repairs out of his own pocket, if there's no real substance to the Treasure Islands, the treasure story, and the map is a bad map anyway. Now, you can see why in these circumstances the skipper might want you to give him a bit of money, at least a bit of money up front, so he can look into this issue, do some research, speak to the local barman, get an expert to tell him whether the map, the geographical coordinates of the map are accurate, do some reconnaissance, and just make sure that island actually does exist, and so on and so forth. So you often get the situation where the skipper is going to want you to at least write a check, or give him a couple of gold coins, write a check for a bit of money, to reassure him, not only to cover him for the costs of investigating this Treasure Island story, but also to reassure him that you are also committed. And there's nothing that reassures someone more than if his partner is actually in a partnership, then if the partner is prepared to put his hand in his pocket too. And you have to remember that this, just as in the case of a no-win, no-fee piece of litigation, it's just the same as this analogy of the Treasure Island adventure. This is a partnership, a business venture. It's not you paying a lawyer taximeter rate as you go, with the skipper taking absolutely no risk. This is a business partnership. Okay. Now, anyway, let's assume that he's satisfied himself that there is $1 million on this treasure island, and you're happy that with the share he said he's going to take, or rather the cap that he's going to put on the final bill for doubling up on his hourly rate as a captain of a ship, and so you're off. Now, nevertheless, there are other issues. What about port fees on the way? You have to stop off at Gibraltar or Bermuda or wherever it might be, and you're going to have to pay port fees. Let's say that you need a navigator. It's actually an island that's notoriously difficult to find. Perhaps you're not even sure it exists. And so you need to employ the services of a navigator. Now, what about pirates? Yeah, and what about some wild natives who might be living on that island and might chase you off, or even worse, might cause you some serious physical injury? So you might want a soldier on board the ship too, a navigator, soldier, and you've got these port fees to pay. Well, I've just given it away there, of course. What I'm talking about is expenses, and the simple fact is that when you're sort of like sailing through the gentle, calm waters just after, let's say, you've started your trip, and perhaps you've not quite left the river estuary yet, you're in a nice protected inlet and everything seems fine and dandy. Of course, when you get out to the open sea, you meet all sorts of perils and pitfalls. So that's why it's important to think about pre-issues, before you've actually commenced legal proceedings and gone to court, and after you've gone to court. Because if you do issue proceedings, you're actually taking your opponent to court in a piece of no-win, no-fee litigation, then clearly you're going to run into these perils and pitfalls. And of course they are, as I say, court fees. You have to pay the court money so the court system can run properly. You may have to employ a navigator, and that might be an expert, an expert witness of some description, and then a soldier. So that's the barrister or counsel in the case, in this analogy. You may well need that soldier, particularly at the end of the journey, i.e. at trial. So the big question is then, who's going to pay for all of that? The captain's already paying for his ship and his crew. So now you've got two choices. Either you can, you've got kind of three choices really. You can put your hand in your pocket and pay for those extras, those expenses. You can ask the skipper to put his hand in his pocket, or you can go to a merchant on shore, a bank, and ask him to lend you the money. So if there's a danger you're not going to be able to pay him back the money, obviously he's going to want quite a seriously high rate. But nevertheless, that's another way of paying for those extras or those expenses. Now, you can appreciate that in the second two scenarios, ultimately it's going to mean parting with more of that treasure, isn't it? So in these type of no-win, no-fee arrangements, you will often find that if you are expecting the law firm to assist you with these expenses, these extras, the technical word is disbursements, then you're going to have to part with more of your treasure. It could be 35%, it could take you up 10%, 15%, 20% more than you originally expected. Had you not had to kind of go out into the open sea, which is actually commence legal proceedings and drag your opponent kicking and screaming towards a trial, because that's the only thing that's going to make him see sense. And unfortunately, it's a fact of life that even if you think you can kind of get away without going out into the open sea, well, those sort of places are few and far between. You know, just like for any sea voyage, you really do need to, or any battle, you really do need to be properly prepared, and it's best to prepare for the worst case scenario, as it were, rather than to wing it. That's where you get into real trouble. Okay, now there is another issue that you don't worry, hang in there, this will all make sense. There is another issue. Let's assume that there is a monster on the island, okay? And when you are going to get there, there is a very real risk that you might get eaten by the monster. Now, so this commercial endeavour is unlike a lot of other commercial endeavours or adventures, insofar as, all right, there's no monster, you've lost a lot of time, but you lost a little bit of money, but you've really not lost much else. Certainly, you've not been eaten. So, in the case of a no-win, no-fee, in the case of civil litigation generally, there is this monster. And you'll probably have already guessed what that monster is. It is having to pay your opponent's legal costs if the endeavour, if the adventure is a failure. Okay, so that is quite a serious thing, isn't it? And, just to jump out of the analogy for a moment, when I was a young lawyer, I worked for a manufacturing company. It wasn't a big manufacturing company, it was sort of 5 million, 10 million turnover. It did work for construction companies, one big construction company in particular called Balfour Beatty. And I remember being in a boardroom meeting with the lawyers. This is before I was a lawyer myself, fully qualified anyway. In a meeting with the lawyers, and they basically eyeballed our operations and finance directors and said, at the end of the day, if you don't, that they were refusing to pay our invoices. They said at the end of the day, okay, sue us. Maybe you have got a good case. But are you going to risk it and risk losing and risk having to pay a massive legal bill if you do, because we're going to employ the best lawyers in the land? That risk alone, it's almost like the monster may not exist. It's sort of like someone tells you there might be a monster on the island. It's enough to dissuade most people from, getting on the ship in the first place. So how do you deal with the problem of a monster? Okay, well, you've got your soldier, so you've got your protection. But there's still this danger. So you probably have guessed the answer. You take out insurance. I mean, that's where the insurance industry sprung up, and I think it sprung up in Renaissance Italy. Great trading, Italian states were great traders, great bankers as well, and the shippers just simply could not risk sending a ship all the way to East India for some exotic spices and jewellery and whatever, and have that ship, hit the rocks, and they'd just simply lose a whole ship's. Not only would they lose the cargo, but they'd lose the ship as well. And it became financially ridiculous for them to embark upon that exercise. But of course, the insurance industry could spread its risk. So one ship to one trader, that's a risk that he can't afford to take, losing his one ship. But of course, if you've got a bank that has insured 100 ships, suddenly it becomes a proper commercial venture and a bit of a commercial partnership between the bank and between the ship owner. So you have the same thing in no-win, no-fee litigation. You have an insurance industry who know that the law firms and in particular obviously the clients are exposed, and they provide this insurance. And it's an interesting form of insurance, because if you are eaten by the monster when you arrive at the treasure island, the insurance will pay out. You've lost, and it will pay out and shower your surviving family in riches. And if you actually win, then you will have to pay the insurer basically a share of the treasure. So it's another slice of the pie. Another slice of the pie is having to go to the banker, the insurer, who is taking the danger away from you of being left penniless, or worse, your family having been left penniless, you having been eaten by a monster. So that is the no-win and no-fee regime, and the litigation landscape around it in a nutshell by means of that analogy. Okay, finally, to recap and to summarise, no-win, no-fee litigation in England and Wales is not about, like it is in America, taking a share of the treasure. Okay, it is allowing the lawyer to double, typically, might not be double, but typically if the risk is 50-50, his hourly rate, and to say, but I will cap that at a percentage of the treasure, half or 25% of the treasure. So it's not purely taking a share of the treasure. Does that make sense? And you may ask why that's the case. There are damages-based agreements, treasure share-based agreements in the UK now, but for reasons I won't bore you with, they simply don't work. I think it's something culturally, ethically, perhaps we're, as a legal system, we're unhappy with the idea of kind of a pure treasure hunt type arrangement with the lawyer, perhaps because we fear the lawyer may be motivated to do something dodgy. Hopefully by means of this analogy you've got a better understanding of no-win, no-fee litigation and a better idea of how to go about instructing lawyers and whether or not to get involved in a no-win, no-fee type arrangement. I think that the most important consideration for someone who's thinking about doing no-win, no-fee is, is it going to be a long voyage, and are there lots of perils and pitfalls? Obviously, if you think your opponent is going to fight tooth and nail, then and there's a bit of a monster at the end of the adventure, then you probably want to look at no-win, no-fee litigation, because otherwise you could be spending a lot of money out of your own pocket in order to get the ship out of harbour. And of course, once you are into like a lengthy period of proceedings, once it's heading all the way to a trial, you are going to have quite a hefty legal bill. You will have already paid for a hefty legal bill by that point, which might be causing immense strain to your finances, and you'll also be faced with the threat of an opponent's legal bill if you lose. So is your opponent likely to capitulate quickly? If so, then maybe the traditional taximeter hourly rate is the way forward. If not, and if the claim value is big enough such that it interests the law firm in question, you might like to consider a no-win, no-fee retainer. If you want to contact Redwood Legal, we tend to, as I alluded to, want to do an initial investigation, proper preparation into the eyeball you as well into your case, and we do charge a preliminary fee for that. In order for us to do a preliminary review, in order for us to eyeball you in your case, take your instructions and look at the treasure map and make sure that it's a good map, that could take a few hours, particularly if there's a lot of documentation in your case. So what we recommend is that clients upload their documents to us, and that we review the amount of preparation work that's required and quote you for a preliminary review of your case, with a view to then, if it looks like a strong case with a decent claim value, going over onto jumping tracks onto a no-win, no-fee retainer down the track. Do please press the subscribe button and help us get up those YouTube and Google rankings. Bye for now.